Good morning and welcome to the 28th meeting in 2019 of the Finance and Constitution Committee. Can I remind members to at least put their mobile phones into a mode that will not interfere with proceedings, please. The only business on our agenda today is to undertake scrutiny of the referendum Scotland Bill at stage 2. This is our second day doing this. I welcome the Cabinet Secretary for Government Business and the Constitutional Relations, Michael Russell, MSP, and his officials to the meeting. And I now therefore move to stage 2 of the referendum's Scotland Bill. And to begin, I call Amendment 85 in the name of Patrick Harvey, grouped with Amendments 86 to 89. Patrick Harvey to move Amendment 85 and to speak to all other amendments in the group, please.
Thanks, Convener. Good morning. Still slightly out of breath from running up the Royal Mile. This group is about false statements, and I wish it could apply to ScotRail train timetables. But that might have been out of scope, so it's just sticking to the issue of referendums. While my surface struggles to life, let me remind members of what I'm sure you're all aware, Section 106 of the Representation of the People Act 1983. This is the legislation which makes it an offence during an election to make false statements about a candidate. It's not been used hugely often, but it has been used in the past, even to the point of overturning an election result and forcing a constituency election to be rerun. There is no equivalent in relation to referendums, and this was the issue that I was seeking to address with this group. There's no equivalent legislation preventing people or bringing in consequences for making false statements in relation to referendum campaigns and the issues or the process of conducting those referendum campaigns. And that's what I sought to introduce with this group of amendments. And I think we all are conscious across the whole political spectrum of the way that our democracy is being affected by the prevalence of deliberate falsehoods within campaigning. In fact, the UK Parliament's Digital Culture, Media and Sport Committee has looked at this and published information about the extent of the interference. Social media platforms have begun to change their policies in relation to what kind of advertising they will carry, and mainstream media have begun to be more vociferous in chasing down, fact-checking and exposing deliberate falsehoods. Yes.
I'm grateful to Patrick for taking the intervention. As I understand it, Section 106 applies to constituency election campaigns, so it doesn't apply to national media campaigns. I'm not sure if that's right or not, but that's my recollection of it. But the examples that Patrick Harvey is using are examples of national media campaigning, rather than the kinds of things that candidates might say about each other in a constituency. So it wouldn't be captured, even in the context of elections, by any of the offences legislated for in Section 106. So there's an inexact analogy, isn't there, between what 106 does and what his Amendment 85 does?
I think that's fair to say. What I'm trying to do is to look at what 106 in the Representation of the People Act is intended to achieve, and yes, apply it in a broader way in relation to referendums. I believe that in relation to elections, it should also be applied in a broader way. It doesn't only apply to statements by candidates. It creates an offence that can be committed by anyone, including national political campaigns, making statements about candidates. This amendment is looking to broaden that and to say that it should cover false statements, objectively false statements, not merely expressions of contestable opinion, but objectively false statements in relation to the issues as well as the process and conduct of a referendum. I think that approach should be taken in relation to elections as well. This bill is about referendums. I would just draw members' attention to the fact that just in recent days, for example, an entirely concocted tweet purporting to be in the name of Jeremy Corbyn in response to the London Bridge attack, claiming that he had stated as his first reaction to those events, a man was murdered by British police in broad daylight. This is entirely untrue. It would be defamatory if Jeremy Corbyn was to identify the originator of it, defamatory or libelous, I suppose. But it doesn't engage any aspect of electoral law. If something similar was to happen during a referendum, you know, there is again a lack of any legislation to deal with that, and it has happened in relation to referendums. There were many legitimate contestable claims made, for example, in the 2016 EU referendum, but to state that Turkey is joining the EU was objectively false. It was a false statement. To state that the EU prevents the UK from speaking out and protecting polar bears was an objectively false statement. And there were others that I'm sure members are familiar with that I don't need to go into in huge detail. So what I've sought to do with this group of amendments is to create the possibility that a criminal offence would be committed when objectively false statements are made about the conduct of the poll. For example, if in a future referendum in Scotland, using the new electoral franchise, assuming that bill also passes, if someone was to go around saying English people aren't allowed to vote in this election and trying to use that claim as a voter suppression technique, they would fall foul of this offence. If they were to say, no, young people aren't allowed to vote in this, you know, 16 and 17-year-olds aren't allowed to vote in this referendum, they would be making an objectively false claim, a voter suppression technique, and they would fall foul of this. But it would also address the matters that are connected to the question on which the referendum is being held. And again, it would not apply to legitimate expressions of opinion, contestable claims. I think this would be good for our economy or bad for our economy. But it would be for the court to determine whether objectively false claims have been made. And that's set out in Amendment 85. And Amendments 86 and 87 deal with the consequences. And I think it is legitimate to say, as in 87, that if such claims are made by a permitted participant or a designated organisation, as opposed to an individual, the criminal consequences should be higher. Following that, and I would perhaps mark 85, 86 and 87 as you know, one aspect of this. 88 and 89 then deal with the political consequences, and I think that's an optional extra, if you like, following the creation of the offence. This would be about challenges to the validity of the result. And again, I remind members that a constituency election can be overturned if such claims are shown to have been made. Substantial enough claims have been found to have been made. So this 88 allows a period in which a petition can be brought to the Court of Session to declare the referendum result not to be valid. And it would be for the court to determine whether a sufficient number of persons have been convicted of or charged with the corrupt practice of making a false campaign statement, and that the nature of the offences are adequate to justify a ruling. And that ruling could involve prohibiting ministers from taking action to implement the result of the referendum or imposing conditions. I've made it clear that prohibiting the ministers from taking action to implement the result of the referendum would not prohibit ministers from taking preparatory action, for example, negotiating with another party as to how the result would be implemented, or indeed drafting and introducing legislation. It would be the irrevocable action, the ultimate implementation, which would have to wait until that process had been dealt with. And you know, I think 88 and 89 do give members of the public and campaigners some ability to go to court and say, this referendum has been so brutally interfered with by fake news or false claims as to render its result invalid. I think it's perfectly clear, and I think we all know, that if the level of regulation in relation to the 2016 referendum had been at the same level as exists for an election, it would have been overturned already. The 2016 result would not have stood the same scrutiny, would not have been regarded as having the same legitimacy as an election, given the practices that we all know have taken place, not only in relation to existing criminal offences, but also in relation to deliberate falsehoods that were expressed during that campaign. I think that we should, if we're going to have more referendums, and that is an if we are going to have more referendums in Scotland in the future, we should be holding them to a higher standard, and that should include an equivalent provision to the offence of making false statements in relation to elections. And I move Amendment 85.
Thank you. Murdo Fraser.
Thank you, Convener. Can I thank Patrick Harvie for bringing these amendments and opening up a debate on what I think is quite an interesting topic, which is the whole question of false statements in referendums, and indeed the whole question of sanctions. And in the debate we had last week at Stage 2, when we were looking at the whole question of sanctions for breach of rules, I raised a concern I've had that levying substantial fines long after the event are not a sufficient deterrent, because the campaign groups affected might by that point have no resources, or indeed have been wound up, and it's hard to see what impact that would have. And Patrick Harvie is taking a much more robust approach in here, creating a new criminal offence for those making false statements, a criminal offence which I note could lead to up to 4 years in jail for those who are guilty of it. And I think maybe it might be worth putting this in some context. If we reflect back to the 2014 referendum, some of the statements that were being made in the 2014 referendum, members might remember we were being told that the finances of an independent Scotland would be robust, that the oil price would be over $100 a barrel, and that would mean that the finances would be in balance. We were told that if we voted no in 2014, the NHS in Scotland would be privatised. Clearly that was an untrue and false statement. And of course we were told in 2014, that that would be a once-in-a-generation vote, or indeed a once-in-a-lifetime vote, as the First Minister had it. And that clearly has turned out not to be a true statement. So if the proposal from Patrick Harvie is that those responsible for making those statements, including the current First Minister, and indeed the Cabinet Secretary, and perhaps Mr Harvie himself, should be hauled before the courts and accused of a criminal offence, then I have a certain enthusiasm for that viewpoint. Indeed, if it would be helpful, I could make a citizen's arrest to help the authorities in addressing these issues. But I think that just highlights the concerns around this particular approach. What is a false statement? What is demonstrably false? These are, in effect, subjective matters rather than objective ones. And what I might regard as a false statement, Mr Harvie might take an opposite view on. And so while this approach I think is very attractive, and I would love to see prosecutions of the guilty men and women from 2014, I just can't see how it will work in practice. And the problem is, if you look at subsection 5 of Amendment 5, which is the defence that's been inserted, the person can show if they had reasonable grounds for believing and did believe the statement to be true. I just cannot see how, from a legal perspective, that defence works, because the court is being asked to look into somebody's mind and see whether they actually believe something or not at the point that they made that statement. How a court is expected to do that is utterly beyond me from a legal perspective. And this brings us into the whole area of contestability, of subjective statements, part of the political debate, rather than objective statements that can be tested and meet the correct level that would be required for a criminal conviction. And for that reason why I think I admire Patrick Harvie for bringing this forward, and he makes some important points. I just cannot understand from a legal perspective how this is enforceable.
Alec Rowley.
Yeah, I think I have similar difficulties. I actually think the principle of this, and it is something that we do need to look at, because we are seeing more and more lies, and downright lies. I mean, the example with Corbyn and the London Bridge is a good example of that. But Murdo Fraser talks about the health service being under threat in the independence referendum, but the health service is under threat now. You know, so who's right and who's wrong? And that's the difficulty I see with the implementation of this, and I would be grateful if Patrick Harvey could pick up on that point, because I think the principle's right. I think he's right to say that something needs to be done. We just can't continue, because it's actually damaging our democracy, and we see the kind of political campaigning that takes place in the United States, and we're seeing more and more of that come across here, and you just don't know what to believe. Fake news is a real issue that undermines our democracy. So I do agree with the principle of this, but like Murdo, I find it difficult to see how it would be implemented, the legalities of it.
Okay. Adam Tompkins.
Thank you. Like Alec Rowley and Murdo Fraser, I'm very sympathetic to the intention behind these amendments, which is to clean up political campaigning. And to inject a sorely needed requirement of truth into our political campaign statements. But I just want to reflect a little bit on the reasons why we don't already have these rules with regard to elections. The intervention I made on Mr. Harvey wasn't a point of legal pedantry, unusually for me, but I think is an important point of principle. The Representation of the People Act 1983 is, of course, a codification statute that codifies a number of elements of electoral rules, many of which date back to the 19th century. And in the 19th century, it was, of course, the case that constituency campaigning mattered much more than national media campaigning. And the focus of these electoral rules was, understandably, in the 19th century and indeed in the early 20th century, on constituency campaigns rather than on national media campaigns. But there is no analogy to be made between constituency campaigns in an election and a national referendum campaign. Section 106 of the Representation of the People Act makes it an offence to make false statements principally about candidates. You know, I think we need to reflect on why. I mean, we all know that constituency campaigns still matter, but we all also know that they don't matter as much as they used to, and that national media campaigns also matter a very great deal, whether we're talking about broadcast media, print media, or social media. But we need to reflect, I think, on why these old rules about constituency campaigns have not been translated into rules making it an offence to make a false statement in a national media campaign. And the reason, I think, is not lethargy, but a sense that, you know, converting a political argument about the truth of a claim about the future of the NHS into a legal argument for a court of law that has the power not merely to invalidate a constituency election but an entire national result would be to make a huge change to the nature of our electoral law and indeed of our democratic politics. I don't think would be desirable at all, notwithstanding the shared ambition that Mr. Harvey and I would both have to try and inject a greater degree of truth into our politics than is currently there. So the way I think I would want to proceed here is incrementally rather than through any other means. And I would want an organisation such as the Law Commission or the Scottish Law Commission to take a long, hard look at our existing electoral rules to see if those existing electoral rules that apply to constituencies should apply to national campaigns, and then learn the lessons from that for referendums. I don't think that it would be prudent, notwithstanding the intentions, which I applaud and share, I don't think it would be prudent to lift what are essentially 19th century rules about constituency campaigning into 21st century campaigning about referendums without a lot of much more careful evidence-taking and deliberation on the consequences, intended and unintended, of this than any of us are capable of. So I would have some real and grave hesitations about going down this route in this sort of way.
I also want to contribute. No, Cabinet Secretary.
Thank you, Convener. I want to start by welcoming Patrick Harvey's amendments. I can't support them, But I do think they raise an exceptionally important point, and Patrick Harvey is starting the process of what I think will have to be profound change in how we run elections and referenda. But these particular amendments do not take us into the position that we need to be in. And I want to particularly welcome comments from Alec Rowley and from Adam Tompkins, which I think are addressing this in a very serious and sensible way. The norms of politics, just as the norms of the Constitution, are in the process of being trampled on in a fairly contemptuous way by the current government. And they're not alone in that, but they are a particular offender. They're self-policing, you would expect, in the norms of politics, where people would endeavour to tell the truth, and there would, of course, be interpretations of what people have said and disagreements, but there would be at least be an intention to try and be truthful. Just like the norms in the operation of the Constitution, for example, and we've seen recently with prorogation, are matters which are normally self-policed, and the media also plays a role in policing them. Both of those things have broken down to a greater or lesser extent, and you could, in drawing a historical parallel, look at the Wild West of elections in the 18th and early 19th century, where anything almost went. And there does need to be a re-examination of how elections and referenda are conducted in terms of truthfulness and the ability to judge in what is an extraordinary landscape of information. A wall of information is constantly available, and how to pick out from that wall the things that are true and the things that are false. So this is a very important thing that we need to think about. But we're not in a position yet where we can come to a conclusion, and I agree with Adam Tompkins that somebody, the Law Commission is a possibility, there may be other bodies, needs to look at this very carefully indeed. We're not totally without defence. The point that is made about the Corbyn tweet is an interesting one, but the issue there is if it is defamatory, and I don't think there's any doubt it is defamatory, the issue is to find out who issued that tweet and to act within the existing law at the present moment. And of course, some of the things we've been talking about during this process of imprints, some of the things in terms of how the Electoral Commission operates should help to some degree with that. But regulating the truthfulness of campaign statements can't be done effectively at this stage, and it can't be done by these amendments, regrettably. A number of witnesses, for example, said that the Electoral Commission would not be the appropriate body to assess the truthfulness of any campaign statement, and they were right. The approach this takes is different, and is in seeking to make it an offence and making sure that there are penalties for it. But the likely outcome of this approach would be a severe curtailment of the freedom of speech. Amendments 85, 86 and 87 would impose heavy penalties on individuals, and this would have a stifling effect on debate because it would inevitably reduce the willingness of individuals and groups to participate. It would probably undermine the information available to voters, not improve it. There's also a more philosophical truth. What body would decide on what is true? The definition of what would be an offence in these clauses is very broad. Matters connected to the question on which the referendum is held, the consequences of a particular outcome. Those are not things that would be easily interpreted in terms of statements of fact. The conduct of an election, the conduct of a candidate, the personality, the way in which a candidate conducts themselves are much clearer than those particular issues. Now, we can point to statements that we know were factually incorrect, such as the Turkey example have been used, made, of course, amongst others, by the Prime Minister himself. But making our courts the arbiter of that truth during an election campaign would also be exceptionally difficult. I think many of us would anticipate that that would produce a flurry of court action in the midst of an election campaign, and I think that that would have a very disruptive effect on anything we understand to be elections. I don't think there would be any restraint in using this, or particularly in complaining about this, and I think we would enter into a very difficult position. And indeed, there is also, I think, a likelihood that the effect would be so pronounced in terms of drafting of these that it might make proposals incompatible with the right to freedom of expression in Article 10 of the European Convention on Human Rights. Regrettably, because I am sympathetic to doing something, but not to doing it this way. So, in addition, Articles 88 and 89, Amendments 88 and 89 would put in place a process to allow the result of the referendum to be challenged. Now, again, the underpinning principles there I don't think are wrong. It's right that problems with campaigns should be identified and dealt with as soon as possible, rather than resolved months later. That's why there are, in this bill, penalties for breaching campaign rules and giving additional powers to the Electoral Commission. I believe the way in which this is put would be immensely disruptive, and as Adam Tompkins has indicated, would actually make the ability to get a result out of any referendum and implement a result almost impossible. I really can't support any of these amendments. If the committee were to pass them, then they would have to have substantial and radical amendment at stage 3 to have any prospect of doing anything other than wrecking the process of having a referendum, unintentionally, I believe, but wrecking it. But I do think Patrick Harvie has produced something very important, and I hope out of this, then a number of people in this committee, and certainly I will be thinking about how we can take the issue further and who should be examining this closely and what the outcome of that should be in terms of electoral law.
Thank you, Cabinet Secretary Patrick Harvie. And to Presser, withdraw your Amendment 85, please.
Thank you, Convener, and thank you to the members who've taken part in this debate and recognised, I think, that this is a subject that is going to have to be addressed in one way or another. The committee, in its Stage 1 report, didn't agree with the views expressed by some that the Electoral Commission should be an arbiter of truth. And I entirely understand why that wasn't something that we agreed to. But we're going to have to decide at some point how it is that deliberate falsehoods will be challenged. If not by an independent body like the Commission, then it seems to me that the courts are the most obvious alternative route. And so I've brought an amendment to begin that debate and to try and flesh out how that could be achieved. I think it's very clear that it's not achieved with the current situation. I mentioned defamation as a potential route in my opening remarks, and the Cabinet Secretary also mentioned that. Defamation is there for an individual who feels aggrieved about the way that they've been misrepresented or statements that have been made about them. It is clearly not an adequate response in terms of the political consequences. If a politician, either during an election campaign or a referendum campaign, was to take action under defamation law, all they would do is draw more attention to the claim that's been made about them. The political consequence can only serve to advance the false claim that's been made. It has no ability to overturn or call into question the result of the democratic exercise that's been interfered with. So defamation is there for the individual, but it doesn't achieve the political consequences that are necessary. Adam Tompkins, I think quite rightly, asked us to consider why it is that long-standing laws that relate to constituency campaigns from a time when constituency campaigns were much more the core and the focus of the democratic experience haven't over time been applied to national campaigns. And I suspect that there is an element of the frog being slowly boiled in the answer to that. But I would ask members to contrast with the current election, for example, which doesn't apply these rules at the national level, just as they wouldn't be applied at the national level in a referendum. We all had a bit of a laugh around the claims about Joe Swinson and the squirrels, didn't we? That was all a bit of fun. Those were false claims, fake news, if you want to use that phrase. But if in a constituency election in Joe Swinson's constituency, the squirrel lovers of East Dunbartonshire had been so offended by those claims and so taken in by them that it had affected the result of the referendum, Joe Swinson would have some degree of call to the courts in relation to that. If the same claims had been made during the leaders' debate about Nicola Sturgeon, who is the leader of a political party that's contesting that national election but is not a constituency candidate in that election, there would be no similar ability to appeal to the courts for a political consequence. So this is a gap This is not a deliberate choice not to apply constituency rules at the national level. It is a gap that has opened up and that, given the importance of national campaigns, both in elections and in referendums, I think it needs to be filled. I don't think that this is about confusing subjective and objective questions. The courts already, although defamation is not an adequate response to this kind of situation, it is evidence that the courts are well capable of telling the difference between an objective and a subjective claim. A forecast about oil prices or economic consequences is never, at the time that it is made, a true or untrue statement in simplistic terms. A forecast is a forecast. It involves a degree of modelling, it involves a degree of evidence, it also involves a degree of guesswork, and it will always be seen in those terms. Just very briefly, I don't think this is would involve a breach of ECHR. I'm very committed to ECHR and to the principle of human rights, but part of the principle of human rights is that none of them are absolute. They all require to be balanced against one another and to be applied in a proportionate manner. The intention of legislation in this area is to prevent bad behaviour. And I think the existence of it in relation to constituency campaigns has, broadly speaking, prevented bad behaviour rather than resulting in a slew of cases before the courts. It's been quite rare that it's had to be enforced. And I think if we achieved it in relation to national campaigns, either for referendums or elections, it would also have that effect of preventing bad behaviour. I welcome the fact that Adam Tompkins and the Minister have both suggested that a body like the Law Commission might consider this further. For the time being, I will ask permission to withdraw 85 and consider whether there's another way to bring this debate to the Chamber at stage 3, because whether we result in a change to the bill at this point or not, I think our Parliament as a whole needs to debate these issues in more depth in the future.
Okay, thank you, Mr Harvey. Does any member object to the amendment being withdrawn? No member objects. I therefore call Amendment 86 in the name of Patrick Harvey, already debated with Amendment 85. Patrick Harvey to move or not move?
Not moved.
Call Amendment 87 in the name of Patrick Harvey, already debated with Amendment 85. Patrick Harvey to move or not move?
Not moved.
The question is that Schedule 6 be agreed. Are we all agreed?
Yes.
We are agreed. The question is that Section 36 be agreed. Are we agreed? Yes. We're all agreed. I now call Amendment 70 in the name of Adam Tompkins, grouped with Amendments 71, 72 and 73. Adam Tompkins to move Amendment 70 and to speak to all amendments in the group.
Thank you, Convener. The amendments in this group relate to Section 37 of the bill, which is the power that Scottish ministers would have, if the bill is enacted, to make regulations that modify legislation as they consider necessary or expedient. And the breadth of the breadth of Section 37 was one of the issues on which our witnesses were most critical when they gave evidence at stage 1. The purpose, however, of Section 37 is to ensure that this framework legislation for referendums in the future is sufficiently dynamic, I think is the word that the Minister has used many times, sufficiently dynamic, sufficiently flexible. And the committee took a nuanced position on Section 37 in its stage 1 report by supporting the objective of Section 37 to provide for dynamic legislation for referendums in the future, but at the same time welcoming what was then, and I hope still is, the Cabinet Secretary's openness to consider amendments which would limit the use of that power while still meeting that policy objective. And my amendments 70 and 71 are designed to deliver on exactly that, to maintain the policy objective of Section 37, but to limit the use of the ministerial power to modify enactments in 2 ways, Convener. First, to remove the words "or expedient" from subsection 1 of Section 37, so that Scottish ministers may by regulations make such modifications of this Act as they consider necessary, but not as they consider necessary or expedient. And secondly, in Amendment 71, to leave out the words in brackets "or proposed modification" from paragraph A of section 37(1), so that Scottish ministers may by regulations make such modifications of this Act as they consider necessary in consequence of or in connection with any modification of any other enactment, but not of proposed modifications. These were the two elements of the overbreadth, if I can put it that way, of Section 37, which attracted most criticism from our witnesses, including Alan Rennick of the Constitution Unit, who said that the inclusion of proposed modification would seem to offer ministers a mechanism for making what he described as almost any change without the need for primary legislation. That's an extraordinary power for this Parliament, or indeed any Parliament, to give any minister, and it seems to me that it needs to be curtailed without undercutting the stated purpose of the section. So that I hope explains Amendments 70 and 71 in my name in this group convener. Amendment 72 is in the name of the Minister, and I won't speak to that. I'll let the Minister do that for himself. Amendment 73 in my name is a procedural amendment which would mean that any regulation made under this provision would be subject to a super-affirmative procedure in the Scottish Parliament rather than merely an affirmative procedure which simply seeks to protect this Parliament and its legislation from being unilaterally changed by ministers without appropriate parliamentary scrutiny. So it adds a procedural safeguard to the substantive curtailments of ministerial discretion which Amendments 70 and 71 would seek to make.
Thank you. Cabinet Secretary, to speak to Amendment 72 and other amendments in the group, please.
Thank you, Convener. I think we're pretty close to agreement, Mr Tompkins and myself, on the changes that need to be made here. I think we're into the fine-tuning and detail of those changes. I have accepted, as I accepted in giving initial evidence, that we need to reassure people about this section. These amendments make adjustments to the delegated power in Section 37. They preserve the dynamic nature of the legislation, but they do provide some bulwarks against that legislation being misused, which was a concern of the committee. I welcome Amendment 71 in the name of Adam Tompkins, which removes the option of bringing forward modifications based on proposed modifications for other elections or referendums. Having heard the evidence from some stakeholders expressing concern that the powers currently drafted could be used to amend the framework by the back door, I had decided to bring forward this amendment myself, but it wasn't required, so I will support and would encourage the committee to support Amendment 71. I can't support Amendments 70 and 73. Amendment 70 would remove the option of Scottish ministers bringing forward for this Parliament's approval amendments which, in their view, improve the referendum process which are not strictly necessary. An example of this might be the amendment which we've already dealt with to make Easter Monday a dies non, which we've discussed and included in the bill. If we wanted to make such an amendment using the Section 37 powers, the idea of taking a proportionate approach to what is a comparatively minor matter, we would wish to have the power to make modifications which are expedient. Standardising the dies non across polls is sensible, reduce the risk of confusion, but it wouldn't be beyond doubt whether it can be described as necessary and could be challenged as such. Counting officers and electoral registration officers could, I'm sure, deal with different processes at different polls, but it does increase the risk of inadvertent errors. I think by what the amendments were suggesting, then the power is constrained. I think in this case, eliminating the words makes it more difficult to use the framework in a sensible way. Amendment 73 would introduce a requirement for any draft regulations under Section 37 to be subject to consultation and accompanied by an explanatory document. I'll not be supporting this amendment because I'm against that, but because it's not necessary. The first part of the amendment deals with consulting on draft regulations. The committee, I'm sure, appreciates that consultation with stakeholders on any proposed amendments around elections is a given. The Scottish Government routinely consults on proposed secondary legislation concerning elections, such as secondary legislation needed for local government elections and Scottish Parliament elections. But I do have sympathy with the suggestion that an element of statutory consultation should be required, as discussed at stage 1. And that's why I brought forward Amendment 72, which actually requires Scottish ministers to consult with the Electoral Commission on the use of the Section 37 power. So it fulfills the requirements in Adam Tompkins' amendment and goes further. As we've heard, the Electoral Commission is a valued source of independent expert advice. The Commission is well placed to comment on any proposed use of the power and to help ensure any proposals are as appropriate as possible. taken together, of course.
I'm grateful. I'm a little unclear, Cabinet Secretary. If there is time for the government to consult the Electoral Commission, surely there is also time for the wider consultation that Amendment 73 would require. And would it not be reasonable to suggest that if that wider consultation took place, that might to some extent allay the concerns that are motivating Amendment 70 and allow that amendments or adjustments that are expedient but not necessary would have greater confidence if they're subject to that wider consultation?
Yeah, I don't disagree with you, and therefore I think if there's a criticism of my Amendment 72, it might be that they should it should be drawn more widely to consult other bodies as well, and I'd be prepared to consider that. But the normal practice is to consult the Electoral Commission on such issues. That is in other legislation too. But if the member is suggesting sorry, that we should look at Amendment 72 at stage 3 to widen that, to have a wider consultation, if that is what Mr Tompkins was seeking to achieve there, then I'm willing to consider that. The second part of the amendment, however, is the requirement that any regulations which are laid before this Parliament should be accompanied by an explanatory document. That change is also unnecessary. It's already practiced for any draft regulations which are laid to be accompanied by a policy note which addresses the matter set out in Amendment 73. So I do think the amendments that I have proposed meet the objections that the committee has and do so in a way that is proportionate. But if there is a feeling that the Amendment 72 requires to be slightly widened to include other bodies, I'm quite happy to consider how we might do that.
Any member want to contribute? Another member want to contribute? Sorry, when you go.
Put on record that I think these amendments are, I think all the amendments in this group are reasonable. I welcome the Cabinet Secretary's comment that he's willing to look at a further amendment at stage 3 to widen the consultation. I would hope that that meets, or at least holds open the possibility that stage 3 can meet Adam Tompkins' intentions in this. So I'll support the government's position on this, but would like to see the Cabinet Secretary and Adam Tompkins see if it's possible to work together to achieve something that's agreeable for stage 3 that broadens the consultation.
Anybody else? No, in that case, Adam Tompkins to wind up and to press or withdraw Amendment 70, please.
Well, I'm grateful to both the Cabinet Secretary and to Mr Harvey for their remarks with regard to this group. My concern, just to put on the record now, about Mr Russell's Amendment 72 is that it would impose on the Scottish Ministers a duty to consult the Electoral Commission, but it would not confer on the Scottish Parliament the right to see what the Electoral Commission's advice is before voting on any statutory instrument under Section 37. Yes.
Happy to include that in the consideration at stage 3.
Indeed. And what I was going to go on to say was, if that could be included for consideration at stage 3, then that would certainly meet my concerns. But given the nature, tone, and substance of the comments, I'm happy not to press Amendment 70, to move 71 and not to move 73 at this stage, subject to those considerations about the finer tuning. I think the Cabinet Secretary described it being revisited in time for stage 3.
I'll take these things in order. So the first question is you want to withdraw Amendment 70. Am I correct?
Yes.
In that case, does any member object to Amendment 70 being withdrawn? No member objects. I therefore call Amendment 71 the need that Adam Tompkins already debated with Amendment 70. Adam Tompkins to move or not move?
Moved.
Move. The question therefore is that Amendment 71 be agreed to. Are we all agreed? Yes. We're agreed. I call Amendment 72 in the name of the Cabinet Secretary. I already debated with Amendment 70. Cabinet Secretary to move formally?
Moved.
The question is that Amendment 72 be agreed to. Are we all agreed?
Yes.
I call Amendment 73 in the name of Adam Tompkins. I already debated with Amendment 70. Adam Tompkins to move or not move?
Not moved.
The question is that Section 37 be agreed to. Are we all agreed?
Yes.
The question is that Section 38 be agreed. Are we all agreed? Yes. We're agreed to these two sections. I therefore now call Amendment 110 in the name of Jackie Bailey and a group on its own Jackie Bailey to move and to speak to Amendment 110, please.
Thank you very much, Convener, and I'm happy to move and to speak to Amendment 110. This is my final amendment about timescales, Convener. I have been persistent. I'm clearly an eternal optimist, and I live in the vain hope that the Scottish Government might even agree with me on this one. The purpose of this amendment specifies that the period to launch a challenge to the result of the referendum via judicial review should be 8 weeks rather than the 6 weeks set out in the bill. I think that increased period for reflection and discussion before engaging in legal proceedings is a helpful one. I think it's always better to allow time for deliberation before asking for something as substantial as a judicial review. And it's consistent with the theme surrounding the majority of my amendments, which is about ensuring more time for the process. I've finished. Too slow, Mr. Mason.
But you can still contribute at this stage if you wish, Mr. Mason.
Well, I think it was just to make the point, and maybe Jackie Bailey would like to intervene on me, as to, just could she give us a little bit more reasoning on the 8 weeks as compared to the 6 weeks rather than 7 or 9 or something? Did she have a particular reason for the 8 weeks? I am wondering if she is going to intervene before I finish.
She gets a chance to wind up and answer if she wishes to. Any other member wish to contribute? Patrick Harvey, if you feel you need to.
Just to say that I've resisted Jackie Bailey's other amendments on timings. I'm more open to this one than I have been to the others. In particular, the practical barriers to initiating a judicial review, especially for those who don't come with financial resources, are significant. And I think there is perhaps a reasonable case for adding a little more time to allow those barriers to be overcome. But I'm also open to hearing what the Cabinet Secretary has to say.
And we'll hear from him right now. Cabinet Secretary.
Well, Presiding Convener, their persistence in the end pays off. I not only thank Jackie Bailey for bringing forward Amendment 110, having listened to Jackie Bailey's points, and notwithstanding I'm intrigued by John Mason's view that there is some mystical element to 8, which Jackie Bailey knows about but nobody else knows about, I think that this is a defensible position to have. I think Patrick Harvey's point is a sensible one. It is a big step for people to take to challenge, and I think they should be given the opportunity to do so in a slightly longer period, so I'm happy to accept the amendment.
Jackie Bailey, to wind up and to press or withdraw.
Convener, I think I'll quit whilst I'm ahead and I'll press the amendment.
Okay. The question, therefore, is Amendment 110 be agreed. Are we all agreed? Yes. We're agreed. The question is 39, Section 39 be agreed. Are we all agreed? Yes. We're agreed. I now call Amendment 88, then with Patrick Harvey. Already debated with Amendment 85. Patrick Harvey to move or not move?
Not moved.
I now call Amendment 74 in the name of Adam Tompkins and a group of its own. Adam Tompkins to move and to speak to Amendment 74, please.
Thank you, Convener. This amendment would provide that Scottish ministers, Scottish public authorities, the Scottish Parliament and members of the Scottish Parliament must respect decisions made by referendum and, so far as is consistent with their functions, must implement decisions made by referendum. And the amendment is designed really to start relatively late in this legislative process, a debate that I wish we had started much earlier, which is to think a little bit more carefully about what the relationship is between decision-making by referendum and our ordinary processes of parliamentary politics. And I think, speaking just for myself, that we've made a bit of a mess of this in the United Kingdom. I think that we have had resort to constitutional referendums for a variety of reasons that we can argue about, which are probably subjective rather than objective truth, for a variety of reasons which we can argue about, and we don't always know what to do with them after they've happened. In other words, the relationship that we have in Britain and in Scotland between parliamentary democracy and popular democracy or direct democracy is untidy. And I think unhelpfully untidy. I don't think it's doing the political process any favours, and I think it's doing it some harm. So this amendment is designed not to tie up all of those loose ends. I don't think any amendment could, but this amendment is designed to at least tie up some of them. And to try and legislate for what the relationship ought to be between government and parliament on the one hand, and decisions made by referendum on the other. The other element of the role of referendums in our democracy, which I think this bill might have usefully addressed, but hasn't usefully addressed, is this issue of whether referendums are binding or whether they are merely advisory. And if they are binding, on whom are they binding, and what is the nature of the bond? Is it a legally enforceable bond, or is it a political commitment, or what have you? And this amendment seeks to kind of, as it were, address that issue by moving beyond it, by saying that referendums decide things, but without, and the decisions are not, the decisions that referendums make are not necessarily binding, but there is a legal obligation, there is a constitutional obligation on those who hold public office to seek within their powers to implement those referendums, those decisions. So I'm not sure that I'm going to press this amendment today. I think it's more than a mere probing amendment, however. It's an amendment which is designed to elicit a debate, or at least a response from the government, about these two questions. What do we want the relationship between parliamentary democracy and popular democracy to be in Scotland? And why do we want to legislate on a referendums bill without first addressing that question as a rather fundamental one? And second, what do we mean by saying that a referendum is merely advisory, or, contrariwise, that a referendum is somehow binding? These are elemental questions about the role of the referendum in modern Scottish politics that I think it would have been helpful to have addressed earlier in the process, but at least we are able to address them now. I've finished.
Right, again, you've got an opportunity to do that. John Mason.
Yes, I didn't want to interrupt him too early, but my apologies for being too late. I'm particularly intrigued. I mean, I understand the bit about implement decisions, and I think it's good that we are having this discussion, because I think, as I understand it, all referenda have been advisory up till now in both Scotland and the UK, although people have committed to accepting.
Apart from the AV referendum, which was binding.
Was binding, thank you. I'm interested in the word respect, as to what he means by that. Does it mean obey? Because, I mean, I respect the result, I think, of every election, but the minute, I suppose, I get defeated in 2010, I respected that result, but I'm immediately campaigning to win at the next election that I'm standing in. So does respect mean you don't campaign against the result? Or what does respect mean? Well, he can answer that in his summing up, perhaps.
Any other member want to contribute? Patrick Harvey?
Yeah, thanks very much. I think Adam Tompkins quite rightly says that we do need a deeper debate about the relationship between parliamentary democracy, direct democracy, deliberative and participative democratic systems as well. And it's useful that we've got the opportunity to discuss it. I doubt, much with like my own group earlier today, I doubt that we'll have this discussion. That'll be the last word. I think we do need a longer term reflection. And I think he's right also to acknowledge that the UK has made some serious errors in the way that it has used referendums in recent years. I don't think that this amendment deals with it in the right way. The idea that we would move from a position of saying that referendums are advisory to simply prohibiting advisory referendums, which it seems to me this amendment would do, it would require implementation rather than result in a referendum giving advice to political decision makers for them to consider and decide what to do with. The idea that we prohibit one or other rather than recognising that they are different and distinct and perhaps need different rules seems to go way too far. There's no time scale involved, so it seems to me that if we pass this amendment, members of the Scottish Parliament for all time and in all sessions of the Scottish Parliament would be bound by the result of a referendum that had taken place, however many years ago, it seems to me that it would limit the ability of the people of Scotland to choose representatives for future elections who disagree with the result of a previously conducted referendum. And I think we would also recognise that there's a difference between pre-legislative and post-legislative referendums, which also isn't properly dealt with in this way. I think it's also not properly dealt with in the debate that we've had, and so the amendment asks us to confront some important questions. I don't think it resolves those questions, and so perhaps this is something that, again, we'll need further debate on, but I think we're not at a position where we could pass an amendment to deal with these issues at the moment.
Just wish to contribute? No, Cabinet Secretary, thank you.
I thank Adam Tompkins for the amendment. I think it is prompting a useful discussion. It's a discussion that is related to the wider discussion of how the Constitution works in these islands, because there are different parliaments and different traditions of sovereignty, for example, which is an issue within here. The current Tory party manifesto has a commitment in it to, I think, something called a Constitution and Democracy Commission of some sort. I have to say I expect the worst from it, but if there was to be any good from it, it might be considering issues such as this. What is the proper place of referenda? How do they operate within these different traditions? As we saw in the 2016 referendum, the result of a referendum is not always clear-cut. So there needs to be space for further discussion. And that further discussion has taken place within Parliament. The Brexit example shows that the Parliament actually needs to have the space to decide how to move forward on a decision which was at the very least contested, and we've had earlier discussion about the nature of the campaign, and of course in Scotland the proposal was rejected, as it was rejected in Northern Ireland. The effect of the amendment as it is, if you were to apply it retrospectively and to say what would have been the situation had there been a requirement in the UK to observe the outcome without further debate, we simply do not know. But it would have changed the process, and it might have changed the outcome. For example, what would the actions have been if it had been a requirement in terms of how to leave, when to leave? Would in actual fact the bill for the referendum have been passed in circumstances, and I should remind people of this, and it comes from David Lidington when he was Minister for Europe and the Minister responsible for the bill in June 2015, when he said quite clearly in the debate that this referendum is advisory, as was the case for both the 75 referendum in Europe and the Scottish independence vote last year. That was an assurance to the House of Commons that it was. I accept Adam Tompkins' point about the AV referendum, and that raises an anomaly which we should consider. In addition, of course, we may in future see referendums initiated by a citizens' assembly. And the Irish experience here is interesting and germane. There has not been an automatic assumption or even written into the process an automatic right for those recommendations to be implemented in terms of referenda. Even the celebrated one on the issue of the constitutional ban on abortion was a process of moving towards a position through a committee of the Dáil that eventually decided that the referendum was the right thing to do, and in a country where referenda are much more used than they are here. The Citizens' Assembly could bring forward proposals for a referendum on a wide range of topics in which the Parliament might well have split views across party lines or across other lines. And an unclear legal requirement to implement the result without further discussion or consensus in the Parliament wouldn't be, in my view, the best way to proceed to ensure those elected to represent their constituents on perhaps those issues wouldn't be best for them to follow in that way. So I can't support this particular amendment. I do think it raises concerns which we need to take forward, and indeed this referendum bill has raised a number of those concerns which we will need to look at. It would be important to find a way for any referendum to lead to a consensual outcome. That has proved to be very difficult within the political traditions which we belong to. But seeking to bind members in the Parliament, I don't think is a solution to that. But again, the debate about what the place of referendums are in the constitutional structure, how they apply in different democratic and constitutional traditions, is important and should continue for discussion. So I would ask Adam Tompkins not to press it, but I certainly would wish to continue to have debate and discussion about how referendums are used.
Okay, thank you, Cabinet Secretary. Adam Tompkins to wind up and to press or withdraw Amendment 74, please.
Well, thank you, Convener, and thank you to Mr Mason, the Minister, and Mr Harvey for their thoughtful questions and contributions to this debate. I think it is a debate which is worth having. I've already indicated, Convener, that I don't intend to press this amendment, but perhaps I can just take 2 minutes to respond to some of the questions and points that have been raised. First of all, in terms of what does respect mean, there's no intention here, Mr Mason, to create any legally enforceable duty. This would not be a question for the court to determine whether a minister or a member of the Scottish Parliament has or has not respected the referendum. I suppose it's an attempt to prevent referendums becoming what the Canadians once called never-endums. That referendum questions somehow are not determinative. Referendum outcomes are somehow not determinative of the questions which have been put to the people in a referendum, and that referendums are about making decisions, even if those decisions don't formally or legally bind parliaments. Absolutely.
Again, would time come into this in some ways? Is he thinking that you know, it would be binding for a certain amount of time, and then after that it wouldn't be binding, or what?
To be honest, I hadn't considered that question. Mr Harvey raised that in his contributions, and I think that is a very interesting question to think about. For how long, if at all, should candidates in future elections to this or any other parliament be bound by referendum decisions that were taken at some point in the past is a question I hadn't given sufficient thought to, and would need, I think, to be more carefully thought through before taking this further forward. In response to the other major point that Patrick Harvey made, there's no intention here to prohibit advisory referendums or to turn advisory referendums into somehow binding or mandatory referendums. If that's the intention that's conveyed by the words, then the words are unfortunate. The attempt is simply to try and bring some clarity to what is at the moment, I think, a very murky and unhelpfully murky. As I said in my opening remarks, I think the unclarity around this is doing harm to our political process. What is the relationship? What is the relationship between our ordinary processes of parliamentary democracy and the extraordinary event of holding a referendum? That we do not know the answers to those questions, I think, is doing us harm.
Grateful for the Adam Tompkins taking the intervention. Wouldn't you think it's fair to say that at least a substantial amount of the murkiness and the lack of clarity that we're living with at the moment is the result not of legislation or referendum rules, but the politics of a recent very substantial referendum in which, for example, the Brexiteers do not agree amongst themselves what Brexit means, what implementing the result in 2016 means, what leaving means. And if they don't agree, then how could any body, whether government or parliament or anybody else, be bound to respect something which the winning side cannot even define?
I've been trying not to make I know there's an election on, but I've been trying not to make politics out of this. But I think that the criticisms that can be made of the 2016 referendum can also be made of the 2014 referendum. And the First Minister of Scotland did say during the 2014 independence referendum campaign that it was a once-in-a-lifetime event and a once-in-a-lifetime opportunity. And everything that she has said and done since, not at the moment, everything that she has said and done about that since 2014, I think, has undermined those claims that she made several times on the record in 2013 and 14. That's just one example. There are many, and let's not get into the into trading examples and counter examples. The point is made. The point is made that there is an unclarity between what is decided in referendums and what the implications of those decisions are for our ordinary processes of parliamentary politics. And when deliberating on a referendums bill, I think it is unfortunate that we haven't had a fuller and franker exchange of views about how we as MSPs understand the relationship between parliamentary politics and the extraordinary things that referendums are. But I've already said, Convener, that I don't intend to press this amendment. I'm grateful to all of the members who've contributed to this debate.
Adam Tompkins indicated he wishes to withdraw Amendment 74. Does any member object to Member 74 being withdrawn? No member objects. I call Amendment 89 in the name of Patrick Harvey. I already debated with Amendment 85. Patrick Harvey to move or not move?
Not move.
I now call Amendment 111 in the name of Jackie Bailey in a group of its own. Jackie Bailey to move and speak to Amendment 111, please.
Thank you very much, Convener. Given my last amendment, I'm hoping that I'm on a roll, Convener, but the Cabinet Secretary is shaking his head. However, conscious as I am that this is the last amendment today, I don't wish to delay the committee unduly, but I think this amendment covers an area of current debate. I think it's fair to say that when anybody objectively considers the outcome of the 2016 EU referendum, they would probably use terms like chaos and uncertainty. We voted, all of us, based on a myriad of different reasons. Some were influenced by slogans on the sides of buses that were patently untrue. There was no detailed prospectus of what leaving the EU actually would mean, what it would do to our economy, to jobs, what it would mean for trade deals, what the actual terms of leaving would be. We've subsequently seen politicians, as been referred to in other amendments, politicians unable to agree, the UK Parliament unable to steer a way through, and a deal that's not widely welcomed, nor is it widely understood. In all those circumstances, it's not surprising that there is a call for a people's vote or a confirmatory vote. Constitutional change is usually substantial and far-reaching. So when constitutional change is made as a result of negotiation between governments and politicians with potentially competing interests, we should put the deal they come up with back to the people for a confirmatory vote. I, of course, am delighted to note the support of the First Minister and indeed the Cabinet Secretary for a people's vote following the EU referendum, and I agree with their view. My argument is simple. We need a consistent position for all referenda on constitutional issues. And in my view, well, I'm on my last sentence, so I'm sure you'll contribute to the debate. And in my view, we need a second confirmatory vote on any plan that is negotiated. So, Convener, I move Amendment 111 in my name.
Thank you. Mr Mason.
Thank you, Convener. I mean, I get the point in some cases that you might want a confirmatory referendum. I just want, my question would be whether you want it in every case. And in particular, I'm thinking of 1997, for example, when we had a fairly clear vote, both for the setting up of this Parliament and the taxation powers. And I think we are facing at the moment a certain amount of voter fatigue and the public not being very enthusiastic about this general election, let alone quite a few others. And I really wonder if we had gone back in 1997 and said to the public, you made a clear decision, we've implemented it or we're implementing it, and now we want you to have yet another vote, really how much enthusiasm there would have been from the public on that. So I just make that point. Thank you.
Any other member wish to contribute? Alec Rowley.
I think the experience of the 16 referendum supports this amendment, because the fact is that it's, in fact, we still don't know, to be honest, what the outcome's going to be. Even with Boris Johnson's deal, it will take years. If honesty was coming into it, it'll take years to try and negotiate some kind of deal, and we could still crash out in a year's time, in June next year. The 2014 referendum, because the outcome of that was no, then we didn't have that period of negotiation. But where after an outcome or a decision, you've got to have a period of negotiation. It is only really then, once you've had those negotiations, that you know what the deal is. And that would be true. I mean, this bill's been brought forward by the government in the hope that they can hold an independence referendum next year. And if they were to win that referendum, then, as we now know for the Brexit vote, there would have to be a period of negotiation before the people of Scotland knew what it was that they had actually voted for and what the deal was. And it just seems to me, given the experience of the 2016 vote, that it actually makes sense that once you know what the deal is, then you confirm, yeah, we want that, or actually we were better off where we were. And that's why I think that on the basis of the experience of the 2016 referendum, that this amendment is the right amendment.
Would the member give way?
Yeah.
I thank the member for giving way. Would he argue then that if the details were known before the referendum, we wouldn't need a confirmatory one, and that might have been the case in 1997, but if the details weren't known, like 2016, then we would. So it would be some cases we would need it.
Well, it's that point that, given that this bill is about a referendum next year, we will not know at that point what the deal would be that we would get with the rest of the United Kingdom. We will also not know at that point whether or not we would be able to get back into Europe. The consequences of that, we would not know. I'm sure Mr Russell and I will argue about whether there would be a border or not a hard border, although we see with the Brexit deal that there is a hard border down the Irish Sea. So in those circumstances, you're actually putting some faith in a question without knowing what the outcome is. And it just seems to me it makes sense that once the negotiation has been done and the deal is on the table, you put that deal back to the people and say this is the best deal we've been able to get. And I'm not sure before 2016 that many people understood exactly the complexities of the negotiations and where we would actually get to. I think that would be exactly the same if the Scottish people voted for independence. The difficulties, the complexities, and at the end of the day, that deal might look something quite different from what people thought they were actually going to get. And in those circumstances, it just seems to me that it's sensible to then put that back to the people and say, is this what you wanted?
Patrick Harriott.
Thanks very much. Alex Rowley says that the experience of the 2016 referendum supports this amendment, and I think he's absolutely right in that statement. But it's perhaps the strongest example of the adage that hard cases make bad law. The fact that the 2016 process resulted in an utter mess, I think is undeniable. But I don't think that means that we are incapable of having referendums that result in some clarity. I think that there are several problems with this. First of all, is what does a constitutional matter mean? Would it be the case, for example, that if a Scottish government, perhaps working with the Citizens' Assembly or a wider public consultation, produced a bill for a new voting system, a new electoral system for the Scottish Parliament, which had already been worked out in detail, which was well understood, might be politically contested, but it was clear and specific. Would that be considered a constitutional matter to change the electoral system, or perhaps the size of the Scottish Parliament? To require a confirmatory vote in relation to those kind of circumstances, when the legislation, the proposal is clear, specific, and well understood, I think would be redundant. And there's a political question about what losers' consent means. John Mason mentioned the devolution referendum that created this place. There were two devolution referendums at that point. One resulted in a very clear outcome in Scotland, the other an incredibly narrow outcome in Wales. But the winners in Wales did not say, count the votes, you lost, suck it up. That's not what losers' consent means. They proactively reached out to those who were on the losing side to try and understand the concerns, to try and account for those concerns in the way that they implemented the result. That's what earning losers' consent is about. And I think it's pretty clear that if a similar approach had been taken by the UK government following 2016, we would already be outside the EU, still inside the single market in a moderate compromise. I would still dislike it, but it would have achieved losers' consent. It would have achieved some clarity, and the case for a confirmatory vote, I might not be happy about this, but the case for a confirmatory vote simply politically wouldn't exist. The question about a confirmatory vote only arises because of the mess and confusion, not because of the fact of a referendum. So I don't support this amendment. However, consistently, I do support the call for returning the current EU crisis back to the people and giving people the chance to cancel it altogether.
Anyone else wish to contribute? Tom?
Very briefly, I think just to sort of echo the comments of Patrick Harvey and John Mason, I think to cite the experience of the 2016 referendum and what followed as justification for a confirmatory referendum is to learn the wrong lessons from that particular experience. The mess of Brexit was ultimately a consequence of two factors. It was a lack of a detailed prospectus and significant time for debate and public engagement beforehand. And the second aspect was what followed with regards to implementation by the UK government, which was characterised by a toxic mix of hubris and incompetence. It would have been perfectly feasible for the UK to have left the European Union as originally scheduled in March last year, but that would have required a different approach from the UK government, engagement with the devolved governments and a recognition of the closeness of the result. I think also there's issues about the definition of a constitutional matter, and I think that the example that Patrick Harvey gave as a potential scenario is illustrative. There's already been an exhaustive debate and agreement and consensus. To have a referendum only to require another one would be redundant and not required. So for those reasons, I'm unable to support this amendment.
Nobody else wishes to contribute? Cabinet Secretary.
Thank you. I'm sorry to disappoint Jackie Bailey. Her role was short-lived in terms of support from me for her amendments. The intention of this bill, Convener, is to set a framework which can provide for any future referendums across the whole of Scotland. On that basis, it does not seek to prescribe different referendum processes for particular subject matters. And indeed, the committee has specifically rejected that approach, and there was debate and discussion both at stage 1 and stage 2 about whether that was possible to do, and the committee concluded, and I agreed with the committee, it wasn't possible or desirable to do so. So this, at the very end of this process, brings back in something, a principle that we had rejected at the earlier start of the bill. But there's nothing in the bill that prevents the framework it would establish being used again on related questions. That would be a decision for the Parliament as ever, and the Parliament could choose to do so. Automatic second referenda are not required. And there are circumstances where that would be blindingly obvious. John Mason mentioned, you know, a massive majority. If you had a majority of 70 or 80% for a proposition, then I think it would be very doubtful that you would wish to return and to take the process again. I think it's also true that there might be required, and this is the flexibility of the process, where, for example, and Tom Arthur has indicated that there, as in the EU referendum, where the information provided to voters was flawed. People had, and Alec Rowley referred to a false prospectus, and found themselves making a decision which many of them now question. And they might also be required in circumstances, if I can make this point, where circumstances have changed, where things are no longer as they were. A commitment to a once-in-a-generation was always qualified by the change of circumstances. And boy, has there been a change of circumstances in terms of Brexit. Or perhaps where manifesto circumstances arise, where a party may make a commitment in a manifesto to a referendum arising out of a certain set of actions, for example, being dragged out of Europe against our will, and in those circumstances a second referendum is required, and a party says so in its manifesto. So in all these circumstances, I would ask Jackie Bailey not to press the amendment, because the amendment conflicts with what the committee has already decided, and also in the way in which it lays out the requirement is not, I think, applicable in all circumstances which she is trying to make it.
Thank you, Cabinet Secretary. Jackie Bailey to wind up and to press or withdraw Amendment 111, please.
Thank you very much, Convener. I intend to press the amendment, but I will reflect on some of the comments from the Cabinet Secretary and indeed other committee members. If the amendment falls, I will consider bringing it back in a different form at stage 3. I always understood that imitation was the sincerest form of flattery, and given the very fulsome comments from the First Minister and the Cabinet Secretary about a people's vote, a confirmatory vote, I thought, and I'm disappointed, that this amendment hasn't received support. I do think it is slightly hypocritical to make the argument that a second confirmatory referendum is required in the case of the EU, whilst at the same time insisting that a major constitutional change in Scotland's status in the UK in a much longer established union wouldn't require that. I understand John Mason's comments about the enthusiasm for the 1997 referendum and the outcome, and it did command considerable support across party and across the country. But that's with the benefit of reflection. It isn't about planning just for the worst case scenario or the best case scenario. Major constitutional issues, in my view, require consent based on what it would mean rather than a vague notion, as we saw in the EU referendum, of simply taking back control, which was arrant nonsense at the time and remains arrant nonsense now. Constitutional change, for me, in the case of a referenda, has far-reaching consequences. It should be put back to the people, and I would much rather run the risk of voter fatigue on substantial issues of constitutional change than make a change which would harm the country without consent. So, Convener, I intend to press Amendment 111.
Okay, thank you, Jackie Bailey. The question, therefore, is Amendment 111 be agreed to, or well agreed? No. In that case, there will be a division. All those in favour, please show. All those against, please show. Any abstentions? There were 2 votes for and 9 against. The amendment is therefore not agreed to. Well, given I'm in the chair, let me think about that for a moment. The answer is no. The question is that a section 40 be agreed to. All agreed. I call Amendment 75, naming the Cabinet Secretary. Already debated with Amendment 4. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 75 be agreed to. Are we all agreed? Yes. We're agreed. The question is that Schedule 7 be agreed. Are we all agreed? The question is that sections 42 and 42 be agreed. Sorry, 41 and 42 be agreed. Are we all agreed? Yes. The question is that a long title be agreed. Are we all agreed? Yes. That brings the committee's consideration of the bill to a close at this meeting. I want to also, for information purposes, inform members that the bill will now reprinted as amendment at stage 2 and will be published at 8:30 AM tomorrow. I understand in the business bulletin, in the business motion for today, the stage 3 is now set for Thursday, the 19th of December, and I want to thank the Cabinet Secretary and members for their participation at this stage 2. I should also have said deadline for lodging of any amendments is noon on Thursday, the 12th of December. Interesting date of these ones on. The next meeting of the Finance and Constitution Committee will therefore be on Wednesday, the 18th of December. I now close this meeting and thank everybody.